What's going on, Moon Gang? The interview you're about to listen to is with Professor J.W. Verret. Now, obviously, he's a professor, but on top of that, he happens to be a lawyer who is heavily involved in the world of market regulation, which means that he has the unique ability to share with all of us what in the world is going on, but from a legal perspective. Throughout the interview, we discuss the contradictory nature of payment for order flow, the high concentration of power in few market makers. He shares his insights and opinions of what's going on with the SEC and Finra, and we even talk about some crypto regulations. All in all, it was super insightful, and it sounds like the year 2022 is going to be a year of fireworks as it relates to market regulation, and I really hope that you enjoy. Hello, Professor Verret. Thank you so much for taking the time to join me today, to join the ape community. How are you doing?
Good to be here, man. Thanks for having me here.
I'll start you off with an easy question. When I was doing my research on you, it seems as if it takes a small forest for you to print out your resume. I'm not sure if you've run into that issue before, but a lawyer, a professor, you are on the Investor Advisory Committee to the SEC, the former chief, economist and senior counsel to the House Financial Services Committee. The list goes on and on and on. So with that being said, could you give us just a little preview of your background and why we're here? Like, you're definitely defined as a person who's in the thick of it when it comes to market regulation. So could you just give us a little, purview, a little snapshot of your history?
Yeah, sure, man. Thanks. Somebody once told me you'll never embarrass a professor by asking them to talk about themselves or their work. People have careers. They're either moles or foxes. Moles specialize. The fox does a little bit of everything. I'm definitely a fox. I do a little bit of everything, man. I teach at George Mason Law School. I teach securities law, corporate law, banking law, and accounting too. I'm a forensic accountant. Sometimes I help people on the side with forensic accounting issues, find the bad guy, that kind of thing. And some economics as well. And I've done some economics work for House Financial Services and sit on some advisory committees for the SEC and for FASB that makes accounting standards. So I like to give advice. I like to have a lot of opinions. And why we're here is my latest focus is on two things, really. Market structure, existing market structure. Is it fair? And my argument is it's not because of PFOF. And you've done some great stuff on PFOF so far. Your show Monday was great, man. And then the future. What does the future hold for market structure and how crypto world, digital asset world is going to upend everything? And that's a good thing. And some of the frictions in current regulation that are slowing that revolution down. So here to talk about all that and anything else.
You're definitely defined as a person who's going to be in the thick of it with this regulation. Very, very exciting. I'm sure there's many quote unquote apes who are excited to hear your particular input, because with it, we've been discussing it from some technical perspectives, some short selling perspectives, but with you, it's definitely much more of the regulatory, lobbying, political. So I think this will give an interesting angle that could hopefully open some eyes of people. So let's kick it off with literally news that just dropped a couple hours ago. It was reported by Bloomberg that the Department of Justice is officially looking into hedge funds and related research firms and some potential incestual relationships between the two that might not all be above board. I guess, do you have any just knee-jerk reaction to that? Any inside commentary of basically these research firms who I'm assuming they're going to be referring to these short selling firms and their connections with hedge funds and more of a general sense, I guess, just abusive shorting?
Yeah, well, start from the first principle that shorting is generally good for the market. Short selling is good. Short selling provides liquidity, provides a match for a trade for a long trader that wants it. Short selling allows the revenue for some of these platforms that are able to provide zero commission trading. They make the revenue off of their short sale lending. So generally speaking, good practice. I like it. Now, fraud's a different thing. If there's fraud going on, that's different. And that's always been the SEC's position too, that they've always said, well, if there's fraud in short sales, and I think probably managers over allege it every time there's a short attack. The managers say, oh, no, it must be fraudulent. Our company's great. Our company's always terrific. Every manager thinks that, right? So there's probably been some historically some embellishment from the management side on that. But at the same time, we know that there's some crooked practices going on in a subset of short sellers too. The SEC hasn't ever been able to really catch them. The fact that the DOJ is on top of this tells me something. It tells me, SEC often refers things to DOJ, and DOJ says, no, we don't have time. We've got a million things to do here. We can't do every securities law case you want. The fact that DOJ is willing to take this tells me that there's something there. I haven't read it. It just dropped this morning, so I haven't read the complaint yet. But there's something there. And if there's fraud going on, if they're making fraudulent claims to the regulator with a so-called whistleblower claim, trying to help a short position, and the underlying facts are not true and they know it, that's fraud. If there are some undisclosed conflicts of interest with analysts getting paid to help the shorts, that's potentially fraud too, and also a violation of a number of rules for investment analysts. So there could be something there, and we'll have to watch the case play out.
Yeah, I think with that, retail, especially starting in January with the insanity of GameStop, have become a little bit more in tune to stories such as this one of like, hang on, terms such as like stock bashing, and we'll get into this a bit, but a little bit of media distortion with it of, I kind of actually agree with you. I believe that certain companies are overvalued. Maybe they have questionable practices. They might deserve to, they're trading at too much of a premium. They deserve to come down. I'm not inherently against the practice. It's like you said, when it's being abused. With this and like much more of where your expertise is, I would like to talk about payment for order flow, some of the articles that came out, and actually a little bit related to the Department of Justice of potential connections of that might be a little suspect of who's getting paid off for what. Before we get into yours, which was written, I believe, in November, a recent one in December, who's coming out of a professor from MIT, titled Commission Savings and Execution Quality for Retail Trades. It was pretty much arguing that payment for order flow is a positive thing, high quality of execution, and it's saving people money. And on the surface level, I've heard this many, many times, especially from market makers who are making money off of it. But what I find interesting is on page 1 of it, they do disclose that they have a financial relationship with Robinhood. It's right there. Page 1, clear as day.
Yeah, that's true.
How is that possible? Like, can I just go pay for my own lobbying, my own like reports and get that out there? And then everyone's like, okay, yeah, this seems above board. Like now, like you might have to walk me through it, hold my hand. I am just a dumb ape, but isn't that like an obvious conflict of interest? Like of when you're paying for research that's positive to you? Hasn't this previously happened in like the tobacco industry when the tobacco industry paid for their own positive reports? Like I just don't get it.
Well, I'm less worried about it than you, Matt. They did disclose it. Look, the paper, look at it. It's not an academic paper. It's not intended to be published in an academic journal. It's very short for a finance paper. I have a lot of respect for S.P. Kathari. He's a great guy. He was chief economist at the SEC for a while. He went there. But the paper is good for what it claims to do. The qualifications raised in the paper make it less relevant for the discussion, right? So the paper says like, hey, we measure against the NBBO. That's kind of all we've got right now. Well, that's an incredibly flawed metric to measure against. And part of the whole discussion here is the fact that wholesale brokers like Citadel can manipulate the NBBO. They can manipulate the yardstick used to measure their own effectiveness by deciding which trades to route out to NBO versus those that they internalize, essentially.
So talking about that national best bid and offer, just to clarify for everyone who might have not heard that, it's just that's what it is. The NBBO, that's the measuring stick. And I actually have a quote from you related to this. Measuring execution quality against NBBO is like measuring your T-ball performance against your grandma's comments. You were the best one on the team, dear. So that's a little bit, a little bit of a loaded comment there. So are we thinking that these market makers, the CEOs of these companies, are they just getting on the pat of the back from their grandmas saying, hey, you're doing great, when in reality we all just kind of know they're playing T-ball and they're not as good as like what's being said there? I'd like to dive into that, and like obviously I'm being a little bit facetious, but in general, can we get into a little bit more of the detail of why that yardstick, the measurement, and even Gary Gensler has said this himself, the measurement is antiquated. He said that this year. So can you go into the detail of why, when these apes are sitting around for the holidays this year arguing with their family members of how they need to be looking into this, can you give us a little bit more detail on like specifically why this is a bad measurement rubric?
Yeah, so it's first of all, there's a wholesale broker choice here as trades are coming in. We get to decide: do we route out to the to a lit exchange where this will be reflected on the NBBO, or do we keep it internally? and match it internally on a dark platform, our own internal matching engine where it won't be reflected on the NBBO. That an algo can help you use that choice to manipulate the NBBO to make it seem like you're giving better execution than you are, especially when, you know, some of these, I mean, Citadel's got patented technology. They have a patent on algorithmic processes that help them to avoid toxic trades, toxic flow, they call it. So that is a system that's not designed to give best execution on an order by order basis, even though the wholesale broker has the duty of best execution on an order by order basis. The SEC regs and Finra regs, as they exist now, say, look, you can't necessarily always measure best execution obligations against the NBBO. But effectively, that's what most people do. And Finra says, well, we don't really have a better metric right now, so we're not going to bring many actions as long as you're, you know, executing better than NBBO. So I think it's due for a whole scale revamp. I think we're going to see more change in the next year in market structure than we've seen since 1975.
Wow. And I know some of this you did touch on, and I'm sure you wanted to touch on quite a bit more in your write-up in November. Robinhood's threat to sue the SEC over broker inducement regulation unlikely to succeed. So we are now kind of seeing this get into the world of politics. I guess it always inherently was, because we know with the GameStop report, with Gendler and his comments, we even see some senators. I believe Pat Toomey was saying he wants to present a bill where you can't ban payment for order flow. And I know on that particular one, you just didn't really agree with him because you think it, and please correct me if I'm wrong, I'm not trying to put words in your mouth, that it is detrimental to our overall system. So I guess that paper, and I'll post it below for anyone who's interested, could you give us some of the key highlights? Because there are some things I want to go over that I found like kind of that particularly jumped out to me.
Yeah, well, so the general counsel of Robinhood said that he would sue in the event the SEC banned payment for order flow, because Robinhood makes most of their profit, at least on the equity platform, from payment for order flow. Mm-hmm. So I said, okay, you know, you now I've known the general counsel a long time, and he's actually a friend of mine. So we've been friends for about 12 years now. I hope he still thinks of me that way too. And I gave him a heads up the paper was coming. I respect him, but I said, all right, you're going to make a big claim. I'm going to bring the other side of the debate in a paper. And I sent him the paper, and I'd be glad to get any comments from the folks at Robinhood's team. Their team's grown a lot in the last couple of years. They got a lot of smart lawyers over there, and I'm glad to hear what they think. But I think that threat is an empty threat. I've seen the SEC get sued before, adopting new rules, especially post Dodd-Frank, in kind of a hasty way. I've seen them lose. I've seen why they lost. And in this paper, I do a line-by-line analysis of the requirements in the law for what the SEC has to do and has to prove, the economic analysis it has to conduct when it adopts a new rule. And I look at that, I compare it to the cases where the SEC's lost or the SEC's won in the past. And I say, my verdict is ultimately, if you bring the suit, you're going to lose. You're going to fall flat on your face, man. And if Robinhood has a better argument, hey, bring it, man. I'd love to see the paper that says a reply to JW Verret. I'd love that. There's nothing better. And we'll get a little debate going. I'm sure. I guess they probably don't want to do that, because if they really plan to sue, they don't want to give away their best arguments right now, because the SEC can kind of adapt in the rule that it puts out. So they're probably not going to respond on paper, but I'd love for them to. I'd love to get the debate going with those guys.
I think in a particularly a way, maybe it was a weak jab against you, but you had that one in November, and then the one from an MIT professor in conjunction with other professors came out in December. So I wonder if that was like almost a little subtle hit back at you of like why we think this is good and all that. But overall,
I think they had it planned. And they hope it's going to be used by the SEC because one of the lead authors was recently chief economist at the SEC. But look, it's a good paper for what it's qualified to say, but it's just those qualifications make it kind of irrelevant for the regulation. It would be my point.
Out of all the insanity over the past year, I find myself particularly grateful that I am not a member of Robinhood's PR team. It seems like it was probably one of the most difficult jobs of the year. At one point in January, they're saying, Vlad Tenev, he was on with CNBC, and he was saying, no liquidity issue. Everything's perfectly fine. And then the report's coming out, and the day before, there's internal messages saying, definitely a liquidity problem. And then you fast forward a little bit, Gensler in May of this year, he was saying that Robinhood explicitly went out of its way to accept higher payment for order flow in return for worse quality execution. This is coming from the SEC chairman, and he said it was to such an extent that it actually might have overwhelmed any of the fact that it was zero commission. You might have just been better off on a commission one. And it's weird because when you sum this all up, it seems like they are the antithesis of the name of their platform, the mythological story. And I know you have some thoughts, like particularly on the symbolism of Robinhood.
Yeah, in the story, the sheriff of Nottingham is the one who collects the taxes. And this model is one in which, let's be honest here, their business model is one where they collect rents. Where they share rents in the form of payment for order flow shared back with them from the wholesale brokers that are the ultimate kind of collector of rent. I don't want to go too far into the analogy, but no, I've had some problems with Robinhood's business model for a long time, and it makes me sad because I was always a big believer in the ability of digital engagement, iPhone app-based engagement, or Android app-based engagement. In stock trading. And I even did a paper about 6 years ago called Uberized Corporate Law, where I kind of predicted like eventually it's going to be all app-based trading all the time. And people said, oh, that's crazy. What does that even mean? And it's coming to pass, but it's coming to pass in a way that I didn't anticipate. Some of it good, but in the Robinhood business model, I think ultimately bad for investors. But there are other app-based platforms that I think are doing a better job of being more open, more transparent. And so maybe they'll kind of take over in the new regime. I think that'll be better for everybody.
Now, I'm not particularly sure of the one you're referring to, but I was reading a very interesting, I believe, like Medium blog post from Public, which is another brokerage that previously, to be completely transparent, yeah, it did use payment for order flow, but earlier this year, it had said almost like, we don't want to use it. We don't think it's good for the market. And they just came out with an entire very cool breakdown, super transparent, of how they have not been doing payment for order flow, and 70 to 75% of their trades are getting sent directly to a lit exchange, and they're actually getting better execution, which is astounding. That is absolutely astounding. And this commentary that we're hearing, particularly from market makers and whoever is protecting market makers, saying, no, this is better. Like, this is the best traders have ever had it. But then you have this one who's being successful in a regime where it's kind of set up against them. And I'm not too much sure how familiar you are with Tradeat over in Canada there. It's anti-payment for order flow. But I believe their metrics are about 90% go on a lit exchange, and the only time it doesn't is if there's a material like improvement in price. And right there, Public, it seems to be similar, 75% lit exchange, and the other 25% only going off if you can get a better price. Is that a model you're supportive of? Like, do you like it? Do you think that could be improved, or am I completely missing something here?
No, I didn't know much about Public before I wrote the paper. I had seen their stance that they were not taking payment for order flow anymore, and I liked it. I agreed with it. I thought it was principled. But since I put this paper out, they actually reached out to me, and we're gonna talk next week. They said, we read the paper, we love it, we'd love to talk to you. So I'm actually going to meet them for the first time, full disclosure, next week. Wow. To talk about the paper and talk about this effort. I haven't talked with the folks in Canada at Tradeat, but they sound like they're on the same page too. I think this is the future, and I wrote this paper because I want to be part of. Look, I'm defending the SEC. That's a weird position for me to be in. Usually, I'm a critic of the SEC, especially in crypto. I'm the biggest critic the SEC's had, except maybe John Deaton, who's been doing some great work on this. But I'm defending the SEC here because I think they're doing the right thing, and I want to be part of the solution. So that's what this paper is all about.
So with that specifically, if we were to give a soundbite to people, payment for order flow, obviously you are outspokenly against it. Can you give us not only your reasoning behind it, like why is payment for order flow bad? Like what's its downfalls, but also on top of that, we hear it a lot, even YouTubers like me are like, bad, 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 let's get rid of it. What do you see the solution? What do you see the environment to look like that's actually an improvement that the SEC or Finra or all those people can actually, like, I guess, employ in a certain sense that we can live under, and everyone or the market be a little bit of a stronger, less fragile market system?
The problem with payment for order flow is it represents an inherent conflict of interest to the broker's duty of best execution. A duty of best execution that's been described in the law, in legal cases, as a fiduciary duty. That's the highest form of obligation in the law. It's an inherent conflict of interest. It's effectively a kickback. And at the retail level, retail traders don't have the tools to assess the effect of PFOF on the quality of their execution. The whole system is designed to be opaque by design. So I think it has to be eliminated. At the very least, I mean, you can start by just saying, look, what's the big argument for PFOF? It provides liquidity. Okay, let's ban PFOF for the 500 most liquid stocks. Right there. I don't see what Robinhood's argument could be to that, other than it cuts in our profit margins. We really don't like it, right? But I think you got to ban it totally, and that'll bring us to more lit execution. It's not to say unlit is an illegitimate venue, but I think we need more lit to get the price discovery and quality of execution that we used to have. And I think it doesn't mean an end to zero commissions, because I think that there are platforms that, if Public can do it, and if Fidelity can do it on everything other than options for Fidelity, then anybody can do it. I mean, I think that it doesn't mean an end to zero commissions. I think that the congressmen, kind of have been told that by Robinhood's PR team, but I don't think it's true.
So for you, the solution, obviously you're against it, and it seems like it's just this conflict of interest. Like, and I would agree with that, because Robin said, hey, we'll take piss poor quality execution in return for more money. Like, they're trying to improve their own bottom line opposed to really caring about their clients. So I 100% agree with it. And I'm sure if we really looked into it and we had unlimited time, I'm sure we could discuss even more really conflicts of interest there. So you're kind of campaigning that the solution is, let's just ban it and then see where the chips fall. And if that's right, like, I'm assuming a lot more trades will just be done on a lit exchange, and maybe we'll get a lot more midpoint trading and have more robust price discovery, probably even more efficiency and liquidity, I would argue, if everyone is fighting for that order flow in an equal sense. Because right now, if you have one person paying for it, no one's fighting for that order flow. Whether you're talking dark pools, market internalizers, or lit exchanges, if one's paying for it, there's no competition for order flow.
Yeah, and that's the competition angle is another one I think the SEC needs to take a look at. And I talk about in my paper, the SEC has a role under the statute as an antitrust regulator, as an anti-monopoly regulator. And the SEC hasn't really used that toolkit very much. And I think this is a chance for them to pull it out.
Definitely. That's interesting. Kind of going off that, and maybe a little bit more of a general sense, and this is probably one of I have two Finra questions for you from your paper. So Finra, and I found this is the first time I actually read about it, was in yours, and I implore all of you to check it out. If I read this right, Finra is a self-regulatory organization, I believe somehow between its members takes in over $1 billion a year. And one of its rules is that I guess for brokers, they're only allowed to spend $100. So there's no conflict of interest. They don't want this gifting to get out of hand. So if you can only do $100 from brokers to whomever, how is that different? How is the SEC or Finra or DOJ not come down on the fact that from market makers to brokers, there's billions of dollars, from exchanges to brokers, there's more money also with rebates. So I'm confused. Maybe I'm too dumb to get it, but if there's $100 gift cap, I'm seeing a ton of payment. I'm seeing a ton of inducement. Why is that a little caveat that everyone's just kind of like being blind to? And they're like, oh yeah, no, we don't know anything about that.
It's inconsistent. I mean, Finra says if you're a broker and you get more than $100, you can't take more than $100 from, if somebody at NYSE wants to take you out to lunch, don't go anywhere expensive. They can't spend more than $100 on you, right? Mm-hmm. But in net rebates from them or in a payment for order flow from a wholesale broker, you can take billions of dollars. It just doesn't make any sense at all.
So like your options are let's go out to Taco Bell and also here's billions of dollars in payment for order flow.
There you go. Under federal rules, that's allowed.
I'm just picturing all of these business tycoons, Wall Street elitists, like meeting at like Chipotle for these meetings. They're like, all right, we can afford this meal, but then they're just talking about billions of dollars of business practices.
You could, on $100, you could at least do, a couple people at Red Lobster, I think.
All right, that's awesome. I like it. In this community, I'm sure we're all hoping they're probably at a Wendy's, but that's more of a community thing. My second question with Finra, like I said, self-regulatory organization. Between its members, it's in excess of $1 billion. Please correct me if I'm wrong on this, but between the governance and board structure of the people who are like making up that, it seems like there's no rule of the fact that Finra, who's supposed to be protecting investors, the people who compose all these boards, they can be in the industry. And let me go with this train of thought for a second. If you have some people over here working that are supposed to protect investors, but simultaneously they're working in the industry who's trying to make money off of investors, and they're working at both, isn't that another conflict of interest? That's another one I just don't get.
Well, I mean, I'm a fan of the self-regulatory organization. I think it limits some of the excesses of government agencies. And when you get all the members of industry around the table, and when you make sure the board's well represented, you've got some brokers, you've got some dealers, you've got some people who are broker dealers, but maybe mostly they're, running mutual fund complexes. When you have different interests all around the table, then they can kind of, match each other and balance out each other. And at the end of the day, the SEC is overarching above this FINRA organization. So I'm a fan of FINRA. I think they, the rule they have to combat these practices, best execution, is not well defined, and it just hasn't worked. And I think it's just time for a ban. I won't blame FINRA for this one. I think the SEC just needs to knuckle up and ban PFOF. They've been thinking about doing it for 40 years. They've always hated PFOF. I think it's time to step up to the plate and just call, say the emperor has no clothes here. This is not fair. This is not best execution. Don't do it anymore.
But do you think, I mean, I didn't know that they were discussing it for 40 years, and it seems like recently it's really picking up steam, and apparently it has been globally as well, banned in the UK, Australia, Canada, the European Commission just completely said no to it. But coming back to like the interest, and I get that of on the board, like I'm just wondering if there's someone on the board who's fighting for actual investors' interests, because you were saying a myriad of interests. I'm wondering, out of all those people, how many ever people it is, it's like, okay, you have the interests of the banks, of the market makers, of these lenders, of other brokers. I'm wondering if anyone there is actually representing the interests of just Joe Schmo like me.
Yeah, I think they're, I'm not as up on the membership of FINRA board, but I know there have been some pushes in Congress to try to open up that board to have a more diverse membership, and that might be a good idea.
Gotcha. So if it's been discussed for 40 years, and obviously other countries have already been against it, and the commentary from Ken Griffin at Citadel, I believe he was doing a Bloomberg talk, and he was basically saying, hey, payment for order flow is an expense for me. Just tell me it's the rules. And he was basically saying, hey, tell me what side of the road to drive on, I'll drive on. So I think he meant it facetiously. He was just saying, hey, I'll play by the rules. Doug Seafood just had also comments of, hey, Fidelity does not accept payment for order flow, and they're getting good execution. I believe that was an interview. So if we have these two leaders between Virtu and Citadel Securities who seem to not be saying, hey, we need it, and a lot of the world saying maybe a bad practice, who in the world is still fighting for this thing? I don't get who's the leftover potential straw man in this argument that's like just keeping the fight up. I'm confused on that part of it, of who is fighting apparently behind like closed doors and keeping payment for order flow alive.
Well, the recipients of it, Robinhood, high-speed guys, I think those lit exchanges that provide rebates. We haven't talked enough about rebates, but rebates is another type of PFOF that the exchanges do. So I think NYSE NASDAQ, CME will be interested in this. because it seems like Gensler wants to rope them together. So Robinhood, NYSE, NASDAQ. Do we take Citadels and Virtue's comments at face value? I don't know. I've heard
not.
Yeah, right. You want to think the best of people, but they might join the fight as well, or be behind the scenes and get trade associations to sue or something like that. Sometimes that's part of the game. So we'll have to see.
Speaking of, I guess, part of the game there, with your connection to politics and there at George Mason and everything, could you shed a little bit light on, okay, I guess, how does the SEC, Finra actually come up with the regulations? How do they get written into law? How does this lobbying work? Is it only lobbying that gets things done? Because I think, like I said, the average retail trader, that's one thing that we really just don't know about. All I'm seeing is headlines of how from this year to last year, Robinhood has how many ever times multiplied its lobbying efforts. And it seems like a pay-to-play structure almost, for people are paying for what they want to see, but potentially not the best for humanity.
I think so far what they've gotten with their investment, and I got to be careful here because I know the people that they've hired. I probably friends with a half dozen people that they've hired. Okay. So they're good people. They're smart people. They're good at what they do. They're the best at what they do. Look, on the Hill, on Capitol Hill, financial services legislation isn't moving right now, and hadn't really been moving much at all since Dodd-Frank was adopted. Okay. I don't see anything moving on this issue at all in the near future. So the ball's in Gensler's court. They've been successful getting some Republican members to jump to their cause. They've linked PFOF to zero commissions, and with the talking point that ban PFOF, no more zero commissions. Of course, we know that's not true. If Public can do it, if Fidelity can do it, it's pretty easy to counter that talking point. But the ball's in Gensler's court. And Gensler's, if you read the speeches, I think that he's got a majority on the commission to do something strong here. And so from there, it's just a question of how it's designed and whether or not the staff's worried about getting sued and losing when they get sued. That's why I did this paper, because that's the last thing I think that could slow them down, is this threat of suit from Robinhood. I think Gensler's got a clear path to do everything he wants to do, addressing conflicts of interest posed by PFOF. The one hiccup staff might be worried about is maybe we'll get sued and lose. So that's why I did this paper, to show, look, guys, if you do things right in the regulatory process, you're going to win. Don't worry about suit at all. That's the point of this paper. The audience for this is the SEC. I want to buckle up the staff to do something tough and know that, I've got their back on this one. I'm against them on crypto, and we're going to have some tough discussions on crypto. Maybe we'll get to do that later. But I got their back on this one, and I think they're going to win as long as they do everything right. Now, the regulatory process, SEC will do first a rule proposal, right? Here's our proposed rule, some initial contours for what we plan to do, and also a lot of questions we want to ask the market about what they think. Then there's a comment period, and that's where your members are going to be important, where your listeners are going to be important. They need to comment into this if they see the points that you and I are making here. They need to comment into the process, and then there'll be maybe half a year or so of comment letters coming in, and then the SEC is going to do a final rule. That'll be implemented maybe end of next year. And I think we're going to see some kind of a ban on PFOF. I think that's just unavoidable at this point. Maybe it'll be a partial ban, but I hope it's a full ban. And then there'll be, I think, probably litigation. And I think I've got the roadmap for how to defend the SEC. So over under, my friends and I have an over under. How many times am I going to get cited in litigation? I hope it's a lot. That's the plan anyway.
So is this one of those scenarios that the wheels of justice just turn slowly, and these types of, it's just huge structural changes that might take time? Because I'm thinking about when the GameStop report came out, I believe mid-October, there was also a companion piece. And then my first thought was, is there infighting, or do you think maybe there isn't infighting at the SEC? They're just trying to best structure themselves so when they really go, like, it's going to be a successful effort?
Yeah, I think they've been slow. It's also important. You may want to link to this. The SEC has a new director of the Division of Trading and Markets, and you can link to his paper. He's got a paper he's a finance professor. So he's a colleague of S.P. Kathari, who wrote the pro PFOF paper. So, right, so they're in the same finance department at MIT. He's got a paper titled Back Running. So it's a sort of a take on the front running idea, which is a part of what PFOF promotes in some instances, latency ARP kind of stuff. And he says, well, look at back running, look at the ability to take linked touch points that the algos do, that the high-speed algos guys can do, to use to get ahead of subsequent orders that were related to the initial orders that they only learned about because the limit orders that weren't really designed to be executed. They were just designed as kind of intel gathering limit orders that were put on the exchanges, exchange-wide. He's got a great paper about that, and he seems like a guy that gets it. So I think that's a move in the direction of a strong approach to PFOF. The fact that his name is Professor Zhang, and I think he's going to be. I think maybe they were waiting for him to come on board. So his first day was December 6th.
I'll definitely check that out. Yeah, we'll get that link for sure. Before we move on to crypto regulation, on that, a little bit related to PFOF, and we're bringing it up, market makers. Obviously, it seems like you're fighting for what you believe to be a safer, more robust system, which right now wouldn't be classified as anti-PFOF. I personally believe that right now, the extreme amount of power concentration in too few of liquidity providers, aka market makers, wholesalers, retail internalizers, whatever you want to call them, I think that's another thing that is inherently increasing the fragility of the system. For example, not too long ago, when Citadel decided to dust off its Twitter account and start firing off hot tweets again, it was bragging that it was the only one that provided liquidity during the insanity of GameStop. And at first, I get that brag. They're like, look how good our business is. But then to me, when I'm now in my later 20s and I'm always being pitched that the US market's the best one ever, it's robust, it's strong, everyone should be investing in it. But it doesn't make much sense to me when things are getting a little bit more tense and there's tension in the system, that we only have one player who's still providing liquidity. That doesn't seem reasonable to me. It just doesn't seem safe. It seems like this safety net is a player rather than a net of players. I guess, do you have any thoughts on that one?
Yeah, and I think it's something the SEC needs to look at here. The SEC has a mission as a competition regulator. And the fact that I think that practices like PFOF and exchange rebates encourage and contribute to the level of consolidation in the market, particularly the level of consolidation on unlit venues and among these two wholesale brokers. And I think that's a component of why the SEC needs to take action. Spread the trading out, move the trading toward more lit venues. Not move it, but allow it to move that way. I think it will naturally move that way if you take out the distortive effect of PFOF and exchange rebates. And the other related issue is the fact that if you look at exchange rebates, the net is so top heavy and price discriminatory. Those exchange rebates are designed so they're specific individual by individual. It's price discrimination, kind of like what Disney does for admission, right? They have the top fee, but they try to make sure that everybody pays exactly their price point. So they charge different prices to people based on how they can reach them with different sized coupons. And so they start with the massive markup. If you just show up at the park, right, they try to hit you at the right top of your price point so that there's no consumer surplus. It's all producer surplus. That's price discrimination, not necessarily illegal, but certainly a competition issue to look at as a competition regulator. And the level of price discrimination we see on the exchange rebate tiers is an issue that, I think they need to take out the old antitrust toolkit and apply it here. And hopefully they will.
Yeah, I definitely hope so too. With all that being said, when I was doing my research on you, a lot of your commentary, public commentary, has been anti-payment for order flow and very in-depth there. But it seems like you have this whole other side where you're very much following crypto regulation. In fact, you were just kind of live tweeting some stuff. And I think at first, it might be helpful for the audience if we really get into, you have commentary on the Howie test when it's coming to digital assets. And also you were referring to safe harbor as that also relates to digital assets. So I was hoping, general sense, what are your thoughts on crypto regulation? Is the government going to be supportive of us, not supportive of us, and all those other things that I just listed to they're important. They're incredibly important. And I think too few of people have even heard those terms.
Sure. Yeah. So let's start with the Howie test. This is the test where the SEC, if the SEC says you're a security, then you have to register with the SEC. There's a long list of things in the statute that Congress adopted in 1933 and another one in 1934 when they created the SEC, created the securities laws. Long list of things that are deemed to be securities, stocks and bonds and all kinds of things like that, some 30 things.
Wait. So we're applying something from 1933 and 1934
to chew on that for a minute. The test,
crypto?
Yeah.
That makes no sense.
Right. That's right.
Okay.
So that's its own problem. Within that statute, there's one idea of an investment contract, kind of a catch-all. And the court in SEC versus Howie defined what investment contract means. And it was a 4-part test, an investment of money with the expectation of profit solely from the efforts of a third party, promoter or a third party. 3 or 4-part test, but depending on how you cut it. An investment of money in a common enterprise with an expectation of profit solely from the efforts of a promoter or a third party. Usually it's the expectation of profits from the efforts of others that the SEC most focuses on to define you as an investment contract, therefore security, therefore you must register with the SEC. Okay. So it's an old test. And the court in the 1940s that developed it was referring back to state securities laws that predated the SEC from the 1900s, 1910s. Okay, so this is a 100-year-old test we're using to decide if a project needs to register with the SEC.
Makes sense.
Now, you're right, exactly. It doesn't apply. It doesn't work in a number of ways. And I think eventually somebody's going to challenge it and win, and then the SEC is going to have to figure out what to do. Right. So first of all, the Supreme Court case in the 1940s, Supreme Court uses words very carefully. Supreme Court says solely from the efforts of others. It's an expectation of profit to come solely from the efforts of others. They're going after Ripple XRP on the basis of a claim that Ripple does some market making and does some custodial activities and does some kind of curating of the ledger, right? But mostly those efforts are not Ripple. The efforts that create profit don't come from Ripple. A literal reading of the Supreme Court's test that laid out would not apply to Ripple XRP. So I think there's some problems with this test. I would design something differently. And I think if the SEC is very careful about the cases it brings, it doesn't bring many cases because it's worried it's going to lose. I think this cat and mouse game doesn't do anybody any benefit, investors or the SEC. I think there are some projects too that say, okay, we would love to come in and register as a security.
Oh, interesting.
What? There was this great quote from the head of policy for the Chamber of Digital Commerce last week when she was sitting and listening to the current chairman and the prior chairman say, just come in and register, talk to us, it'll be fine. And she tweeted, register is what? Right? So securities laws are all designed around there's a stock in an equity interest in a firm that's run by a board. Okay, that's how we used to do things, but that's not how most of these, especially DeFi, properly described DeFi projects, that's not how they work. There's no board, there's no firm, right? It's sometimes it's pure cryptocurrency. It's just pure mined something that relates to maybe a right to data or something, but there's no firm, there's no people working on the thing that you have an interest in their profits. So how do you comply with things like the proxy voting requirements? There's no proxy voting. Yeah. We don't need proxies to exercise governance rights that come with the token. There's no proxy process. We don't need that. That's the whole point of the way these things engage on a peer-to-peer basis. They don't need proxy voting that we send out in the mail or something. So I mean, it's the reality is the SEC is like, I often think of it like, imagine a conversation in the 1910s where Ford has the Model T and they go to the horse and buggy regulator and they say, okay, we want to get this thing on the road. And the horse and buggy regulator is like, well, you need a horse and buggy license to get this thing on the road. And that's clearly a buggy because it's got 4 wheels and it moves on the efforts of someone other than the driver. And you're like, wait a minute. we don't have a horse. How do we comply with the horse and buggy laws? There's all these laws about, have you been to the vet? Has the shoes been replaced on the horse? We have a combustible engine. It doesn't go to the vet. It doesn't have horseshoes. And the horse and buggy regulator's like, well, I'm sorry, but you fit the definition of horse and buggy, and you need a horse and buggy license. And so you got to comply. You got to go to the vet. And you're like, what? I feel like you're not listening to me. We don't have a horse. We don't go to the vet. This is the combustible engine. That's where we are right now. Now, there are more sophisticated conversations than that going on at the staff level, where the staff are trying to engage and trying to figure that out. And hearings in Congress have been a little better. There was a hearing this week. There was less posturing, less kind of peacock posturing than there usually is in Congress, in congressional hearings. A lot of Democrat members willing to listen. Republicans are mostly very pro-crypto, which is good. But a lot of Democrat members willing to listen, which was a nice surprise, and understand the issues, and some very strong pro-crypto. There's a congressman from Florida who's doing a great job on this. So I have hope. The commission itself is going to have a real kind of a come to Jesus moment here, where they realize that they're going to have to work with this industry. They're going to have to tailor rules. In some ways, it'll be helpful if we had some disclosure standards for how to disclose, who's helping to curate the ledger, who's got control of the governance tokens, how a fork would work, if a fork happens or not, or needs to happen. That would be great. Some standardized disclosure about that, probably working with a sub-regulatory organization of crypto experts. But they're just not there yet, but they're going to have to be there. I mean, and it maybe the precipitant for that's going to be Ripple XRP. If the SEC loses, of course, that's going to be a real problem for them. But even if they win, they'll be the dog that caught the car. They're going to have to figure out what to do at that point. They can't just make XRP register as a security, because what does that financial statement look like? XRP doesn't give you a right to profits in Ripple, so you can't just use Ripple's financial statements. That doesn't work. That's not GAAP compliant. So I feel passionately about this too, and this is one where I think the SEC needs to get with the program.
So with your legal understanding of what's going on, if you were a betting man in the Ripple SEC one, who do you think is actually going to end up winning that?
Well, it's going to depend. There's an individual. There's a question of holding the individuals liable, question of determining whether it's a security. So there might be multiple victories or losses.
Okay.
I don't think let me start with, I hate to make a prediction.
Okay.
But at least I'll say this: I don't think the SEC is gonna win everything. I think they'll lose at least one of those motions.
Interesting. And then in the more general sense, with this, and obviously it sounds like the Howie test, it's archaic. You're trying to measure a horse and a buggy, but we have a whole new age buggy. So I guess bringing that to the next level, what do you think the solution is there? So it's just like, don't apply the Howie test and make a new test? Or do you think that crypto should not be regulated by the SEC at all? Like, what do you see the solution to be there?
Well, I think the industry is already trying to come up with new solutions. Industry groups are trying to come up with a new test. Congressman Warren Davidson's a big proponent of crypto, and he's worked with he referred to a new test in the hearing that was held on Wednesday. So I think it has to be a new test. And I think folks would like to register if there was a crypto specific regime that they could register in, a digital asset specific regime. But the SEC is going to have to fix a lot of these things. I mean, just look, simply put, everything corporate governance that the SEC does, boards, proxy voting, definitions of control person and what's an underwriter or not, none of that it fits within DeFi or DAO-based governance models. They just don't fit at all. Forget a square peg in a round hole. You're trying to fit a Toyota into a square peg on a kid's toy. I mean, it just doesn't fit at all.
Man. So you're thinking this upcoming calendar year, 2022, depending on whenever you happen to be watching this video, you think it's just going to be regulation fireworks everywhere, crypto, equity markets. You think 2022 will be remembered as the year of, I guess, like regulatory fighting, of like who's right, who's wrong, just like down in the trenches, getting dirty, and we'll see who prevails?
Yeah, I think so. We haven't talked about a lot of other rules that are coming down the pike, but the SEC's regulatory agenda is probably the fullest I've seen in a long time. So there'll be a lot of fights. And, sometimes I'll back the SEC when I think they're right. Sometimes I'll fight them when I think they're wrong. That's just how I do it, man.
Could you just give us a little bit of a highlight of those other ones coming down the pike, of the other regulations that you think will just be, I guess, useful for retail traders such as myself to at least be a little bit paying attention to?
Yeah, well, one of the most contentious fights is going to be over ESG, environmental and social governance. The SEC is doing a rule on climate disclosure. And, along a spectrum, if you're an energy firm, and you need to disclose the carbon emissions for the last year by your energy producing firm, that's easy. You've already got that information. You've got a team of engineers who know that off the top of their head, right? That's not hard to do. Versus something called scope 3 emissions, scope 2 or scope 3 emissions, where you try to look at, let's say we're not an energy firm and we have to disclose the energy that's being used, the carbon emissions that are being used by our customers as a result of using our products. That becomes kind of onerous and almost impossible for some companies to do. So the fight will be where that climate change disclosure rule ends up, more toward scope 1 for energy firms, or more towards something like scope 2 and 3 for non-energy firms. And I think that's where there's a lot of nuance. And I don't think you have to get political about it necessarily, but there can be a legitimate technical debate about where the right balance is between those two things. And that's where I might engage on this, and where I think the interesting debate is really.
That's awesome. Out of my own curiosity, my final question for you, just because it got a little bit of steam, but it's kind of died off. Any thoughts or input on this concept of taxing unrealized gains?
Taxing unrealized gains on equities?
Yeah, or crypto, just wherever you want to paint it, but just taxing something that's not locked in.
Yeah, so as one of my hats I wear is as a CPA, in a word, nightmare, compliance nightmare. Are you going to really tax unrealized gains? To be fair, that would require that when you have unrealized losses, you get to deduct that from your taxes. If they're going to let me do that, all right, fine. But they'll obviously never allow that.
Yeah, that makes it. You just want to see it cut both ways. Man, I appreciate this so much. I'm sure there's going to be people who watch this and maybe have follow-up questions for you. What's the best way to reach out to you?
So they can reach me on Twitter page at JW Verret.
Okay.
And respond pretty readily there. Probably too often.
Well, once again, I personally appreciate your time. I'm sure all of the apes listening to this appreciate your time. Thank you. And hopefully as these things start to develop, especially within 2022, when we're starting to see those fireworks, I hope to have you back on just so you could be a little bit of a liaison to the average person of understanding what's truly going down. But once again, thank you so much. And hopefully we'll be catching you soon.
Well, hey, thank you, Matt. And, I think it's important. Ape community, you guys have done great on digital engagement, on asset engagement, on taking your own financial futures in your own hands. And I'd love to see your community get more involved in the regulatory process and comment letters and calling people. And we'll send you some links where you can get involved in commenting on things like crypto regs and PFOF regulation, because I think y'all are a powerful force, man. So I'm really glad to just kind of get to know you here.
I really like that idea. And actually, I'll connect with you right after this, and I'll get them once again in the description of this video, all those links, just so people have those as a resource. But this has been absolutely awesome, man. We'll be talking soon. Have a great one.
All right. Thanks, man.
All right, thank you.